My name is Ryan Calloway. I'm 36 years old. And on a Thursday morning in April, I sat in a probate courtroom in Nashville, Tennessee, watching my stepmother's attorney present a will that my father had supposedly signed 11 days before he died. She was composed, confident, the kind of composition that takes practice. She had the document. She had the notary stamp. She had two witnesses whose names I didn't recognize. She had everything a legitimate will requires. What she didn't have, what she had no idea existed, was a recording. 14 minutes and 23 seconds of audio, recorded on a device no larger than a thumb drive sitting in the breast pocket of my father's estate attorney on the afternoon that the will was supposedly signed. My father's voice was on that recording. So was hers. And what she said to him that afternoon, what she said when she believed no one else was listening, ended her case, her credibility, and her access to everything my father had spent 40 years building in approximately the time it takes to listen to a voicemail. Before I tell you everything, please like and subscribe if this story speaks to you. Drop your city and local time in the comments. I want to know where you're listening from tonight. Now, let me take you back 3 years, to the man at the center of all of this. My father, Thomas Calloway. My father was not a complicated man. He built things. That was the core of who he was. He started Calloway Home Construction in 1987 with a used pickup truck, 2 employees, and a reputation for showing up on time and doing what he said he would do. By the time I was in high school, the company had 40 employees and was one of the most respected residential construction firms in Middle Tennessee. He was not flashy. He drove the same truck for 11 years. He wore the same 3 jackets in rotation. He coached my Little League team even when the season ran into his busiest months. He called me every Sunday morning until the week he got sick. My mother died when I was 19. Cancer. 18 months from diagnosis to the end. My father took care of her through all of it and then spent 2 years alone, quietly, before anyone could convince him to even have dinner with another person. He met Sandra at a charity fundraiser in 2018. She was 44. He was 61. She was warm, attentive, and interested in everything he said in a way that I recognized even then as performance, but couldn't prove. They married 14 months later. I was not invited to give a toast. I want to be fair to Sandra. For the first year, she was pleasant to me. She asked about my work, my life, and my daughter Lily. She organized Christmas at their house with real effort. She called my father Tommy in a way that he seemed to like. But money has a way of clarifying things, and my father's money was not small. The company, the property, a portfolio of real estate holdings across 3 Tennessee counties, a retirement account, a life insurance policy with a face value of $800,000. Sandra had no children, no prior assets of significance. She had come from a string of administrative jobs and 1 previous marriage that ended in divorce. I'm not saying those facts make her a criminal. I'm saying they're the context for everything that followed. In 2021, my father was diagnosed with early-stage Alzheimer's disease, and Sandra's behavior changed almost immediately. The changes were small at first. She stopped inviting me to family dinners without explanation. When I called my father on Sunday mornings, she was frequently in the room. I could hear her voice in the background, redirecting, answering questions before he could, finishing his sentences in ways that weren't quite right. My father started saying things on those calls that didn't sound like him. Not confused things, managed things, things that had been prepared. Sandra handles most of that now. We've been reorganizing things, simplifying. You don't need to worry about the business, Ryan. The business my father had built from a pickup truck and a handshake reputation. The business I had worked at since I was 15. The business whose name was the same as my last name. You don't need to worry about the business. In March 2022, I drove to Nashville and asked my father directly if we could sit down and talk about his estate planning, just the 2 of us. Sandra sat in the living room the entire time I was there. She made coffee, she folded laundry. She was never more than a room away. My father told me his affairs were in order. He told me he had a good attorney. He told me Sandra was taking excellent care of him and that I should trust the process. He looked tired. His eyes weren't quite right. I drove home and called my own attorney, a woman named Margaret Hale, who had handled my divorce 2 years earlier and who I trusted completely. "Something is wrong," I told her. "I can't prove it yet, but something is wrong." Margaret told me to document everything, every call, every visit, every time my father said things that didn't sound like him, every time Sandra was present when she shouldn't have been. I started a notebook. I filled 43 pages over the next 8 months. My father died in January, peacefully, at home, the way he would have wanted. He was 64 years old. The Alzheimer's had progressed faster than the doctors had predicted. I was with him last week. Sandra was there. We were civil to each other in the way people are civil when they are both performing composure for a dying man they love. Differently, unequally, for different reasons. He died on a Tuesday morning. I held his hand. Sandra left the room before I did. 3 days after the funeral, her attorney contacted Margaret with a copy of the will. The will left Sandra everything: the company, the property, the real estate holdings, the retirement account, the life insurance policy. Everything. There was a previous will, one my father had signed in 2019, before the Alzheimer's diagnosis, before Sandra had full access to his daily life. That will divided his estate equally between Sandra and me, with specific provisions for Lily's educational trust. The new will, dated 11 days before his death, superseded everything. Margaret called me when she received it. "Ryan," she said, "I need you to come in." Let me pause here for a second, because I know some of you are already doing the math. 11 days before he died, Alzheimer's diagnosis 3 years earlier, a disease that progressively impairs judgment, memory, and decision-making. The legal term is testamentary capacity. To sign a valid will, a person must understand what they own, who their family is, and what they are signing away. My father, 11 days before his death, was not reliably capable of any of those things. Margaret knew it. I knew it. But knowing it and proving it are two very different things in a probate court. Drop the word capacity in the comments if you know what I mean by that. And stay with me, because what proved it wasn't a medical record or a neurologist's testimony. It was 14 minutes and 23 seconds of audio. Margaret hired a probate litigation specialist named David Park. David was methodical, quiet, the kind of attorney who asks a question and then waits longer than is comfortable for the answer. He had handled estate litigation for 22 years, and he told me in our first meeting, "The will may be real, your father may have signed it, but signing it and understanding it are not the same thing. Our job is to show the court the difference." He started with the witnesses. The 2 witnesses on the will, the signatures that made it legally valid, were names I didn't recognize. A woman named Patricia Gould and a man named Stephen Aiken. David located them within a week. Patricia Gould was Sandra's coworker from an administrative job she'd held 3 years earlier. Stephen Aiken was Sandra's neighbor from a previous apartment. Neither of them had ever met my father. "That's not illegal," David told me. "Witnesses don't need to know the testator, but it tells us something about how this was organized." Then he contacted the notary whose stamp appeared on the document, a woman named Carol Dean, working out of a UPS store in Brentwood. Carol Dean told David she had notarized a will, signing approximately 3 weeks before our meeting. She remembered it because the man being asked to sign seemed confused about where he was. He kept asking for his son, she told David. The woman with him said his son was out of town and couldn't make it. I was not out of town. No one had called me. David submitted Carol Dean's written statement to the court. Then he did something that changed everything. He contacted my father's original estate attorney, the attorney who had drafted the 2019 will, a man named Gerald Fitch, who had represented my father's interests for over a decade, who had drawn up the business succession plan and the original estate documents, and who Sandra had apparently believed was now simply out of the picture. She was wrong. Gerald Fitch called David the day he was contacted. He said, "I've been waiting for someone to call." Gerald explained that in November of the previous year, 2 months before my father died, Sandra brought my father to his office. She said she wanted to update the will. She had a draft prepared. She wanted Gerald to execute it immediately. Gerald had concerns. He had known my father for over a decade. He could see the Alzheimer's. He could see my father struggling to track the conversation. He asked Sandra to step out so he could speak with my father privately. Sandra refused. Gerald told her, as the testator's attorney, he had an ethical obligation to speak with his client alone. Sandra said, and I want you to hear this carefully, she said, "Tommy wants me here. He gets confused without me. Just do what we're asking." Gerald did not execute the will that day. He also, because he is a careful man who is doing this for a very long time, turned on the small recording device he keeps in his breast pocket during contentious client meetings. He has done this for years, a practice born from 30 years of disputes over what was and what was not said in attorneys' offices. He recorded everything, the entire meeting, 47 minutes, including the 14 minutes and 23 seconds before he asked Sandra to step out, the window during which my father sat in that office while Sandra told him quietly and specifically what to say and what to sign and who would be taken care of if he cooperated. "Just tell him it's what you want, Tommy. Just say the words." My father's voice on the recording, "I want Ryan to have..." Sandra's voice cutting him off. "Tommy, we talked about this. Ryan has his own life. He doesn't need it. Say what we practiced." Silence. Then my father's voice, quieter, "I can't remember what we practiced." Sandra, "Just say it's all for me. That's all. Just say the words." Gerald Fitch sat in David Park's office and played that recording on a Thursday afternoon in February while I sat across the table and listened to my father's voice for the first time since the funeral. I did not speak for a long time after it ended. David Park looked at me. "We're ready to file," he said. The probate hearing was on April 14th. Sandra's attorney presented the contested will with full confidence, the notarized document, the witness signatures, the argument that my father had been of sound enough mind to make decisions about his own estate. David Park stood up. He presented 3 things. First, Carol Dean's sworn statement that my father had been confused at the signing and had repeatedly asked for his son. Second, medical records from my father's neurologist documenting the specific stage of cognitive decline he was in during the 11 days before his death. The neurologist's written assessment was direct. At that stage, my father would not have reliably understood the nature or consequences of a complex legal document. Third, the recording. Gerald Fitch testified that the recording was made in his office, on his device, during a meeting he was ethically and legally present for. Under Tennessee law, one-party consent applied. The recording was admissible. The court listened for 14 minutes and 23 seconds. "Just say it's all for me. That's all. Just say the words." Sandra's attorney requested a recess. It was not granted. The judge voided the contested will completely on grounds of undue influence and lack of testamentary capacity at the time of signing. The 2019 will, my father's real will, the one he had signed with full understanding and no one coaching him on what to say, was reinstated as the governing document of his estate. Sandra received her portion, exactly what my father had intended for her to receive when he was himself, when he was Thomas Calloway, and not a man being told what to say in an attorney's office. The company passed to me, as specified. Lily's educational trust was restored. The real estate holdings were distributed as my father had originally planned. Sandra's attorney did not appeal. I don't know exactly what happened to Sandra after that day. I know she moved out of my father's house, within 30 days of the ruling. I know mutual acquaintances stopped mentioning her name in conversation, the way people stop mentioning things that have become too uncomfortable. I know she has not contacted me. I don't expect her to. The first thing I did after the ruling was drive to the cemetery. It was a Tuesday afternoon, cold for April, the kind of Tennessee spring day that can't decide if winter is finished. I stood at my father's grave for a while, just stood there. I thought about the truck he drove for 11 years, the jacket he wore until the elbows went thin, the Sunday morning phone calls, the little league season he coached even when work was impossible. I thought about him sitting in Gerald Fitch's office saying, "I can't remember what we practiced," in a voice that was already somewhere else, already moving towards something I couldn't follow him to. I thought about the recording, about what it meant that he'd tried to say my name. I want Ryan to have... He was going to say something true. She stopped him, but she couldn't stop Gerald Fitch. She couldn't stop 47 minutes of audio. She couldn't stop a careful man with a recording device and 30 years of understanding what happens when people believe they aren't being heard. I said what I needed to say at that grave. Then I drove to my daughter's school to pick her up. Her name is Lily. She is 11 years old. She has her grandfather's eyes, that specific dark brown that catches light in a way that always made me think he was about to say something funny. Her educational trust is intact. Her grandfather made sure of it in 2019, when he was himself, when he knew exactly what he was doing and who he was doing it for. Sandra didn't change that. She only delayed it. There are things I've thought about every day since the ruling. Whether I could have moved faster, whether the Sunday morning phone calls should have been more urgent, whether the 43 pages in my notebook should have been 45, 46, or 60. Whether I could have gotten there before she got to him. I don't have clean answers to those questions. I don't think I ever will. What I do know is this. My father tried to protect his family the right way before the disease took his ability to protect anything. He sat in an attorney's office in 2019 and made decisions about the people he loved while he still fully understood who they were. Sandra tried to erase that. She couldn't. Gerald Fitch, a recording device, and a probate court in Nashville, Tennessee made sure she couldn't. And I am standing here running a construction company with my father's name on the side of every truck my company runs, calling my daughter every Sunday morning the way he called me, planting something I hope will still be standing long after I'm gone. That's what my father built. Nobody gets to take that. I want to ask you something before I go, because this question has stayed with me since that April morning in the courtroom. My father loved Sandra. I believe that. Not the Sandra who coached him what to say in an attorney's office, but the Sandra he met at a charity fundraiser in 2018, the one who called him Tommy and made him feel less alone after years of widowhood. That version of Sandra was real to him. Maybe some version of it was real. So here is what I think about. If you love someone, if you genuinely love someone, At what point does the thing you're willing to do to keep what they gave you prove that you never understood what they were giving you in the first place? My father wasn't giving Sandra money. He was giving her his trust. He spent 3 years converting one into the other. And in the end, a recording made by a careful attorney proved that the trust was never really received. Tell me in the comments, have you ever had to fight for someone who couldn't fight for themselves? Tell me what that looked like. And if you know someone whose family is navigating estate documents or elder care for a parent with cognitive decline, share this with them, not for the drama, for Gerald Fitch's recording device, for the reminder that documentation matters, that careful people exist. The truth has a way of preserving itself if you give it the right conditions. My father's name is on the side of every truck my company runs. It will stay there. Subscribe, because next week I'm sharing what we found in my father's personal files after Sandra moved out, and what he had already figured out about her on his own.